Effects of termination of subsequent marriage under Article 42. A. Children of subsequent marriage conceived prior to its termination are considered legitimate. Custody and support decided by the court in a proper proceeding. B. Property regime is dissolved and liquidated. The party in bad faith shall forfeit his or her share in favor of the common children, or if there are none, children of the guilty spouse by previous marriage, and in case there are none, to the innocent spouse. C. Donation per nuptials remains valid, but if the donee contracted marriage in bad faith, donations are revoked by operation of law. D. Insurance benefits. Innocent spouse may revoke designation of guilty spouse as beneficiary, even if such designation is stipulated as irrevocable. E. Succession rights. The party in bad faith shall be disqualified to inherit from the innocent spouse, whether testate or intestate. Both spouses are guilty of bad faith. If both spouses of the subsequent marriage acted in bad faith, all donations by reason of marriage and testamentary dispositions made by one in favor of the other are revoked by operation of law. Article 44. Who may file the petition for nullity of void marriages? Generally, only the husband or wife may file the petition. Specifically, admin matter number 0 to 1110 SC extends only to marriages covered by the family code. Okay. So if married ka with the effectivity of the civil code in relation to marriage, so they ka covered by kaning admin matter. Family code which took effect on August 3, 1988, but being a procedural rule that is prospective in application, is confined only to proceedings commenced after March 15, 2003. The case of Ablasa versus Republic 2010. Okay, exceptions to the petition as to who can petition for the nullity of void marriages. Nullity of marriages cases commenced before the effectivity of the admin matter katong na-mention earlier, and B. Marriages celebrated during the effectivity of the civil code. From the case of Carlos versus Sandoval 2008. Procedure in attacking a void marriage. Generally, void marriages may be attacked collaterally or directly, except when a person in a void marriage must first file for a declaration of nullity in order to subsequently marry. Requisites for valid remarriage. 1. The previous marriage should be judicially declared void or annulled by final judgment. 2. Must comply with the requirements under Article 52 of the Family Code, which states that the judgment of annulment or absolute nullity of marriage, the partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitim shall be recorded in the appropriate civil registry and registry of properties, otherwise the same shall not affect third persons. Safeguard against collusion and no confession of judgment. In cases referred to in preceding paragraph, no judgment shall be based upon stipulation of facts or confession of judgment. Article 42, Subsection 2 of the Family Code. Stipulation of facts, an admission by both parties after agreeing to the existence of any of the grounds of facts that would constitute a void or voidable marriage. Ang confession of judgment is the admission by one party admitting to his or her fault to cause the invalidity of marriage. Okay. Although the admission of guilt of the wife constitute a confession of judgment, the husband was also able to present other evidence to support the allegation, hence there was no collusion. The case of Ocampo versus Florenciano, 1960. Participation of the OSG. The obvious intent of admin matter 0 to 1110 SC was to require the OSG to appear as counsel for the state in the capacity as a defensor vinculi, that is, defender of the marital bond, to oppose petitions for and to appeal judgment in favor of the declarations of nullity of marriage under Article 36 of the Family Code, thereby ensuring that only the meritorious cases for the declaration of nullity of marriages based on psychological incapacities those sufficiently evidenced by gravity, incurability, and juridical antecedents would succeed. In the case of Mendoza versus Republic, (2012). No motion to dismiss. Admin Matter 02-1110 SC, Section 7 prohibits the filing of a motion to dismiss in actions for annulment of marriages. In the case of Aurelio versus Aurelio, 2011. What are the effects of the pendency of action for declaration of nullity? 1. The court shall provide for the support of the spouses. B. The custody and support of the common children. Give paramount consideration to their moral and material welfare, their choice of parent with whom they wish to remain. C. The court shall also provide for visitation rights of the other party. Article 49 of the Family Code. Effects of res judicata. Suffice it is to state that parties are bound not only as regards every matter offered and received to sustain or defeat their claims or demand, but as to any other admissible matter which might have been offered for that purpose, and of all other matters that could have been adjudged in that case. Malion versus Alcantara, 2006. The effect of final judgment declaring nullity are provided for in paragraphs 2, 3, 4, and 5 of Article 43, and by Article 44 shall also apply in proper cases to marriages which are declared void ab initio or annulled by final judgment under Articles 40 and 45. Final judgment in such cases shall provide for 1. Liquidation, partition, and distribution of the properties of the spouses. 2. Custody and support of the common children. And 3. Delivery of presumptive legitimes, unless such matters had been adjudicated in previous judicial proceedings. Article 50, Subsection 2 of the Family Code. All creditors of the spouses or property regime shall be notified of the proceedings for liquidation under Article 50, Subsection 2 of the Family Code. In partition, the conjugal dwelling and lot shall be adjudicated to the spouse with whom the majority of the common children remain. Article 102 and 129 and Article 50, Subsection 4. Generally, children born or conceived within void marriages are illegitimate, except when a. Children are conceived or born before the judgment under Article 36 has become final and executory. 2. Children conceived or born of subsequent marriage under Article 53 of the Family Code. Okay, that's it. Let's go to void marriages. Article 4 of the Family Code states that a defect in any of the essential requisites shall render the marriage voidable as provided for in Article 45. Grounds for annulment that must exist at the time of the marriage. Article 45 of the Family Code. 1. The party in whose behalf it is sought to have the marriage annulled was 18 years of age or over, but below 21, and the marriage was solemnized without the consent of the parents, guardian, or person having substitute parental authority over the party, in that order, unless, after attaining the age of 21, such party freely cohabited with the other and both lived together as husband and wife. 2. Either party was of unsound mind, unless such party, after coming to reason, freely cohabited with the other as husband and wife. C. The consent of either party was obtained by fraud, unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife. D. The consent of either party was obtained by force, intimidation, or undue influence, unless, the same having disappeared or ceased, such party thereafter freely cohabited with the other as husband and wife. E. Either party was physically incapable of consummating the marriage with the other, and such incapacity constitutes and appears to be incurable, or F. Either party was afflicted with sexually transmissible disease found to be serious and appears to be incurable. Nature of an action for annulment. Action in rem concerns status of parties. Res is relation between parties or marriage life or marriage tie. Jurisdiction depends on the nationality or domicile and not the place of celebration. Avoidable marriage under lack of parental consent. Article 45, paragraph 1 provides the first ground for the avoidable marriage, which is the solemnization of marriage of a party between 18 to 21 years of age without the consent of their parents. Note that Article 14 of the Family Code states that in case either or both of the contracting parties, not having been emancipated by a previous marriage, or between the ages of 18 and 21, they shall, in addition to the requirements of the preceding article, they shall 1. Exhibit to the local civil registrar the consent of the marriage of their father, mother, surviving parent or guardian, or persons having legal charge of them in the order mentioned in A. Manifested in writing by the interested party who personally appears before the proper local civil register, or B. in the form of an affidavit made in the presence of the witnesses and attested before any official authorized by law to administer oaths, and 2. record such personal manifestation in both application for marriage license and the affidavit, if one is executed instead, shall be attached to the said applications. May be ratified by the party 18 or above but below 21 upon free cohabitation upon reaching 21. Second ground for avoidable marriages is insanity. Under Article 45, paragraph 2 provides the second ground for avoidable marriages, which is a marriage entered into by an insane party or a person of unsound mind. What is the test of insanity? It is whether the party at the time of the marriage was capable of understanding the nature and consequences of marriage itself. Mental incapacity or insanity is a vice of consent. It can be ratified by cohabitation after insanity is cured or during a lucid interval. Mere mental weakness is not a ground for annulment, but if found grave enough, it may amount to psychological incapacity. Intoxication, amounting to lack of mental capacity as well as somnambulism, are considered unsound mind, as there was no knowledge of what he or she was giving consent to. Insanity must exist at the time of the celebration of marriage. Insanity that occurs after the celebration of marriage does not constitute cause for nullity. The case of Katipunan versus Tenorio, 1937. C. Fraud, third requisite for avoidable marriages. Under fraud, as stated in Article 43, paragraph 3, it provides for the third ground of the avoidable marriage wherein consent to the marriage was obtained through fraud. The party who was the victim of the fraud may, however, ratify the defect in the marriage by voluntarily cohabiting with the party after knowledge of the facts constituting the fraud. Article 46 of the Family Code, any of the following circumstances shall constitute fraud referred to in number 3 of the preceding article. 1. Non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. 2. Concealment by the wife of the fact that at the time of marriage she was pregnant by a man other than her husband. 3. Concealment of sexually transmissible disease, regardless of its nature, existing at the time of marriage. And 4. Concealment of drug addiction, habitual alcoholism, or homosexuality or lesbianism, existing at the time of marriage. No other misrepresentation or deceit as to the character, health, rank, fortune, or chastity shall constitute such fraud as will give grounds for the action of annulment of marriage. Note: the enumeration of the grounds for annulment under Article 43 for reasons of fraud or vice of consent is exclusive. No other misrepresentation or deceit of character, health, rank, fortune, or chastity shall constitute fraud. Next, Non-disclosure of conviction of the crime of moral turpitude. 1. The crime must involve moral turpitude, or the conduct that is contrary to justice, honesty, and morality. 2. Must be convicted by final judgment. And 3. Conviction must be prior to marriage. A crime involves moral turpitude when it pertains to acts of baseness, vileness, depravity in the private and social duties which a man owes to his fellow man or to society in general, contrary to the accepted and customary rules of right and duty between man and man. The case of Teves versus Comelec, 2009. Concealment of pregnancy by another man. The wife must have A. Concealed her pregnancy, and B. Pregnancy is by another man other than her husband. But if the husband knew of the pregnancy, the marriage cannot be annulled on the ground of concealment. The woman was 7 months pregnant at the time she met the petitioner. He cannot claim that the pregnancy was concealed from him and that he was defrauded into marrying her. The case of Bukat versus Bukat, 1941. But where the wife concealed the fact that she was 4 months pregnant during the time of the marriage and was naturally plump, Deliso could hardly be expected to know by mere looking whether or not she was pregnant at the time of marriage. The case of Aquino versus Deliso, 1960. Note: may be ratified upon free cohabitation after the knowledge of fraud. Concealment of sexually transmissible disease. The sexually transmissible disease was concealed from the other spouse need not be serious and incurable. Again, need not be serious and incurable. When the ground for annulment falls under Article 46, Paragraph 3 vis-a-vis Article 45, Paragraph 3, the healthy spouse, through cohabitation, may still ratify the marriage because the defect is in fact of the concealment and not of the gravity of the disease. Hence, even if STD is treatable, the fraud gives the unsuspecting spouse the right to file for annulment. Concealment of drug addiction, habitual alcoholism, homosexuality, or lesbianism. The non-disclosure of drug addiction, habitual alcoholism, homosexuality, or lesbianism must have been done prior to the marriage. Recovery or rehabilitation from STD, drug addiction, and habitual alcoholism will not bar action for annulment. The defect is not the disease, but the fraud which vitiated the consent. Charot. It is the concealment of homosexuality and not homosexuality per se that vitiates the consent of the innocent party. Such concealment presupposes bad faith and intent to defraud the other party from giving consent to the marriage. The case of Almelor versus RTC, 2008. Any other misrepresentation. Article 46 categorically states that any other misrepresentation as to character, health, rank, fortune, or chastity shall not be a manifestation of fraud, sufficient to be a ground for annulment of marriage. The non-disclosure of a husband's premarital relation with another woman does not constitute fraud. It was expressly stated in Article 46 that misrepresentation or deceit as to one's chastity shall not be a basis for an action to annul a marriage. The case of Anaya versus Palaroan, 1970. Okay, next basis for annulment is force, intimidation, or undue influence. Article 45, Paragraph 4 provides for the fourth ground for the avoidable marriage, wherein the consent of one party was obtained by violence, intimidation, or undue influence. Force must be one to prevent the party from acting as a free agent and will be destroyed by fear or compulsion. There is violence when, in order to wrest consent, serious or irresistible force is employed. Intimidation must be one as to compel the party by a reasonable and well-grounded fear of an imminent and grave evil upon his person or properties, where A. degree of intimidation involves age, sex, condition of the person borne in mind, and B. threat or intimidation as not to act as free agent. Note: a threat to enforce one's claim through competent authority, if one's claim is just and legal, does not vitiate consent. There is undue influence when a person takes improper advantage of his or her of his power or position over the will of another, depriving the latter of a reasonable freedom of choice. Among the circumstances that define improper advantage are 1. Confidential, 2. Family, 3. Spiritual, 4. Professional or other relationship between the parties, or the fact that the person alleged to have been unduly influenced was suffering from 5. Mental weakness, 6. Ignorance, or 7. Was financially and emotional distress. Undue influence may be ratified upon voluntary cohabitation after forced intimidation or undue influence has ceased or disappeared. Impotency. Impotency refers to the person's physical conditions or sexual intercourse with the person of the opposite sex is impossible. It does not refer to mere sterility. It refers to inability to copulate and not procreate. To constitute fraud, the concealed impotency must exist at the time of marriage and be continuous and incurable. If incapacity can be remedied or is removable by operation, it's not annullable. From the case of Sarao versus Guevara, 1940. If the potent spouse was aware, it is implied that he or she renounced copulation by consenting to the marriage. When spouses are impotent, marriage cannot be annulled because neither spouse is aggrieved. Refusal of the wife to be examined does not presume impotency. The case of Jimenez versus Canizares, 1960. Sexually transmissible disease, serious and incurable. Affliction of STD is unknown to the other spouse. The other spouse must also be free from a similar STD. Okay. So what are the requirements? Dapat nani nga ground for you to invoke sexually transmissible disease as a ground for avoidable marriages. 1. Should exist at the time of the marriage. B. Should be found serious. And C. Should appear to be incurable. Not subject to ratification, cannot be ratified or validated by cohabitation. Ang sexually transmissible disease and serious and incurable. Who may file prescription and ratification? Okay. If ang ground is lack of parental consent, the people who can file are 1. The party 18 or above but below 21. 2. The parent or guardian who did not give consent. And 3. No 3. Lack of parental consent on say prescription within 5 years after attaining the age of 21. Lack of parental consent on say prescription before the party below 21 reaches 21 years of age. How do you ratify ang lack of parental consent? By free cohabitation of the party who entered the marriage without parental consent after attaining the age of 21. Insanity. Who can file for annulment? The sane spouse with no knowledge of the other's insanity. 1. 2. Legal guardian of the insane party. And 3. The insane party. Kano sa maka-file ang sane person when the ground is insanity at any time before the death of either party. How about the insane person? He can file during lucid interval or after regaining sanity and before death. Can be cured by free cohabitation of the insane party after the insane party comes to reason. For fraud, who can file for fraud? It's the injured party or the defrauded party. When can he file? Within 5 years after the discovery of fraud. Can be cured by free cohabitation of the defrauded party after having full knowledge of fraud. Ground nga force, intimidation, undue influence, you can file the injured party. He can file within 5 years after the disappearance of force, undue influence, or intimidation, but it can be cured by free cohabitation of the injured party after the force or intimidation or undue influence has ceased or disappeared. Next ground, on impotence, who can file? The potent spouse. He can file within 5 years after marriage, but it cannot be ratified by action. It cannot be ratified by action. STD, who can file? The healthy party within 5 years after marriage, cannot be ratified by action. It also prescribes. Marriage not subject to ratification is where one, dili ni ma-ratify nga marriage, meaning madritso junig annul. 1, the spouse is incurably impotent, and 2, one spouse has incurable STD. Reason is public policy and health. Note that though these marriages cannot be ratified, petition for annulment will prescribe in 5 years. Okay, we're almost done. We're just gonna finish this stuff and then we're gonna go to unmarried cohabitation and then legal separation ata. Okay, just carry on, lawyer. Presence of prosecutor. To prevent the collusion between the parties, fabrication or suppression of evidence, the prosecuting attorney or fiscal shall appear on behalf of the state, stipulated in Article 48 of the Family Code. In a legal separation or annulment case, the prosecuting attorney must first rule out the collusion as a condition sine qua non for further proceedings. A certification by the prosecutor that he was present during the hearing and even cross-examined the plaintiff does not suffice to comply with the mandatory requirement. The case of Corpus versus Ocho Terena, 2004. The effect of pending decree of annulment. The court shall provide for the support of the spouses and support and custody of common children under Article 49. In determining which parent should have custody of them, their moral and material welfare shall be given paramount consideration. The case of Luna versus Luna, 1985. Effects of the decree of annulment. The same with the decree of nullity. The effects provided for in paragraphs 2, 3, 4, and 5 of Article 43 and Article 44 shall also apply in the proper cases to marriages which are declared void ab initio or annulled by final judgment under Articles 40 and 45. Okay. Let's try to compare void and voidable marriages on the next issue. Bye-bye.